Hello. In this clip from our Justia webinar, your bar license is trapped in the 20th century, or is it? Multi-jurisdictional rules and proposed changes. Charity Anastasio and Micah Bookdahl review some of the temporary and permanent conditions that allow lawyers to practice outside their jurisdiction. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Right. And that's very similar to the change that Utah did to their rule. And I actually would attribute that change to the pandemic, because I think there were so many lawyers that were leaving certain more populous areas, maybe going and staying with family in other states, and really needed to practice somewhere. And they did it sometimes they authorized it on a temporary basis. We actually have this in another slide. Sorry. But they authorized it on a temporary basis, and some of them have rolled those pandemic exceptions back. But some of them, I think, realized, hey, the sky did not fall. Let's keep this. This doesn't hurt anything, right?
Well, I think I know a lawyer who's been, I'm not going to name the state he's in, but he's been practicing law, out of a condo in St. John for probably 40 years. And so, it's like, he did that forever and nobody cared.
Right.
So it's really just post-COVID when all of a sudden everybody started doing it, and then states started looking at it. Otherwise he would have sat there thinking, like, what's wrong? Like, I would never even thought there was anything wrong with it when I started doing it, 30 years ago. Right. So,
right.
So some of those COVID changes, like all of a sudden everybody was doing it. Everybody's work from home, everyone's remote, everyone's hybrid. And so that kind of blurs it a little bit more.
Right. When I started doing the practice management advising work at the Washington State Bar years and years ago, I remember a member talking about how he had, he lived on one of the islands in Washington State, which is lovely. And he was international law, in-house counsel. And international, I think, is probably the places where this really in some ways started, because it doesn't make any sense for him to have an office that is beyond his home, because all of his clients are not here and on weird time frames. And so he practiced that way for 30, 40 years and nobody ever noticed, right? But now we are there's many exceptions for in-house counsel. It's one of the biggest ones in all the states I see, as are the federal only. Some of them make it clear and some of them don't. But let's talk about, let's just kind of get down to the nitty-gritty of where can you practice and how do you practice. On a temporary basis, pro hoc vice is the standard. Unfortunately, what requirements there are for pro hoc vice are not standard. All states are different. All states have their system. You cannot presume you will get it, right?
That's the biggest thing. That's the biggest thing on sort of the marketing side of things, is that you can't, when I always tell people, you can't presume pro hoc vice. Like, you can't just assume, like, oh, I'll go get a piece of work out of Kansas, and then just get admitted pro hoc. So you can't assume that. And also you have to be careful with how often you go back to the well, right? Like, a lot of states will start looking like, okay, this is the fifth time, like, you should be licensed here. You can't keep doing this. And so, so there is a big difference between, sort of how you approach it and how often.
And you really have to look at their intention behind that rule. Right? It is intended to be temporary. It is intended to be for one case. It is intended to be for, this case has expanded its borders where I have to address this issue in another state, but it's still the case that is in my normal jurisdiction. Admission by motion is similar, but it depends on the state and the type of cases and the type of court, whether or not that's an option. We talked about the pandemic exceptions being extended in some states, but don't presume it will just because you were authorized 2 years ago. You're going to want to look at the rules again to make sure. And then there's a lot of little minute kind of exceptions. I mentioned in-house counsel, but I see in some 5.5 rules, or even in other rules, they cite other places sometimes where there's exception for military spouses because they move so much, and it really makes their bar license just worthless almost, because by the time they actually get admitted by, some why am I blanking on the word? Their, reciprocity or comity, whatever the state calls it. When they finally get that, they're getting assigned somewhere else. So there's some exceptions for military spouses in a few states. The UBE, the Uniform Bar Exam, has some elements of exception to it because now that more states have it, you might be able to transfer it here or there. And then there's some states that actually even have pro bono as an exception. Ohio is actually one of those where if you're doing an authorized pro bono work, you can do it in that state as long as you've signed up by a particular rule, you've registered. So those are temporary. Some of the permanent options, federal only. Florida v. Sperry case. If you practice solely in a federal practice area, you usually what the immigration lawyers that I work with at American Immigration Lawyers Association do is on all of their communications, they say where they're barred. I'm barred in Florida practicing immigration law exclusively. And they will put that on their business card, their signature block, their website, every communication, because all it says in the rules is your letterhead. But most of us don't use letterhead that much in the different practice areas. So just put it on everything. Make it very clear. And then you have to avoid actually practicing locally. So if there's a state issue, you need a local counsel for that issue, somebody on staff or somebody outside of your firm that you associate with. In-house counsel, one of those Missouri decisions was actually said that in-house counsel has to be barred in Missouri. That shocked me. That's the first time I've seen that as not an exception.
Yeah, I always just, even I had an in-house role not long after I passed the bar, and I figured you really just needed to be licensed somewhere to be like a member of the bar someplace. And then it really didn't matter where you were operating. Of course, like, again, I wasn't necessarily I wasn't going to court. Most in-house are not going into court, right? Like, and, they're going to use local counsel in those types of situations. But, also talk about federal, there are places like California that say, like, if it's a federal practice, you can be from anywhere, right? Like, we don't care, as long as it's federal only, as you said. So it's really, I think the other thing too is, a little bit outside the scope of the bullet points on the slide, is, talking about, you and I have had a lot of conversations about New York, right? And so, up until, New York still has what many consider a very archaic, physical office space requirement. That's,
Bona fide office in New York. It's one of the very few places that still has that requirement. And so just recently, it looked like that was finally going to be removed. And I know, what big law firm doesn't have a New York presence? They always want to have a New York presence. It can be very expensive. And so the House and the Senate, basically, working together with the bar, we're eliminating the need for a bona fide office, a physical presence. And so just, that was just recent, like in the last, 9 months or so. And all of a sudden it was rejected by the governor. Like, it was squashed after making it through the bar and everybody and every place else. The governor quashed it. And so it's still in place. And, you and I have had conversations. I'm like, well, somebody's got some, powerful lobbies, whether it's commercial real estate brokers, maybe it's local trial lawyers, so it's just interesting that you do have these situations where they finally get to the point where, again, someone trying to establish an office in New York is then basically told or reminded that you need to have a bona fide office. Now,
Are there lots of law firms that have improper bona fide offices in New York?
Oh, yes.
Absolutely.
So many flying under the radar.
Sure. I see them all the time. I end up saying to firms like, is that a real office? What are the, what? So it's interesting when you just look at it from sort of that standpoint, which again lends itself back to sort of economic protections.
Right. And practicality lending itself, it makes great sense. We could all be virtual. Why don't we permit this? Realizing that there's other forces at stake here, because I thought of course that would pass, and you corrected me, and thank you for doing that. I will give you that point. You did get that one right.
Well, who would know? Who would think that the governor would be the one that said oh, bona fide offices, right? Nobody would think that, right? It's usually people at the bar that are, again, protecting their own turf. Again, they had powerful people in powerful places, eliminating the attempt to make it easier to establish an office in New York. Everyone wants to establish an office in New York, and they're going to make it hard for you to do that.
Yeah. Some jurisdictions have some permitting of mediation and arbitration. It's pending. Some of them specifically say that it has to be originating in your own jurisdiction, though, on negotiations or mediation or arbitration. Many permit you to have local counsel. So sure, you can do things with local counsel. And some of the little nuances on that in-house counsel exception that I'm seeing in some of the states now too, is that they say you can do this as long as it's an activity that doesn't require pro hoc vice. So basically, probably not court, but you want to make sure you look at the rules and see when it is that they say you need that, and you're giving advice that has originated from somebody that is local counsel. So to make sure that you don't just not have local counsel, that you still have the right people telling you the right things. Already mentioned the pro bono. In some places, that's a permanent exception. And authorized by local jurisdiction. I've also seen, some of them say authorized by Ohio law. And in one, I've seen tribal law. So that's an interesting one. That's probably mostly West Coast. There's many tribes with their own sets of rules, and actually most of them don't require bar admission at all. So I knew somebody that was practicing law when they were in law school in tribal court. So you've got to look at the rule. That's the importance of it.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.